what if the employer, so let's say, that Mr. Anup is the employer and he's saying that I am not doing well, I'm going to pay you only 1500 rupees. I will not pay you 4600 as you are entitled to do so. Okay, so of course I'm going to go forward and file for a claim that my employer is supposed to pay me 4600 rupees, but my employer is only paying 1500 rupees. So there is a difference of 3000 rupees, right? And 3100 rupees, and I am claiming that from my employer, which is Mr. Anup. Okay, so who is going to hear my claim? Appropriate government is going to appoint commissioner. Okay, this could be the labor commissioner, okay, a regional labor commissioner or the labor commissioner. This person will be hearing my claims arising out of this act. Okay, now when an employee has any claim in the nature referred to any subsection 1, meaning कि payment of less than minimum rates of wages हुआ, correct? तो आपको employee himself or any legal practitioner can authorized in writing to act on his behalf, या inspector भी or any other person acting with the permission of the authority can apply. So section 20 में who is going to hear your claims? It is going to be the labor commissioner, the regional labor commissioner. Okay, what are the claims going to be about? For payment of less than required wages, correct? How are you going to do this? You can do it yourself. You can have a lawyer do it for you, or you can ask the inspector to take cognizance of this and get this done through him. Okay, you have to do this within a period of 6 months from the date on which minimum wages or other amount becomes payable. How do I know when it is payable, guys? Relate it back to the Payment of Wages Act. What did the Payment of Wages Act say? कि payment of wages कब होना चाहिए? Of July, I have to go to the Labour Commissioner within a period of 6 months from 7th of July. When it becomes payable, उस तारीख से 6 महीने के अंदर I need to present my claim. How will I present my claim? What is the format of the claim? Form of application by employee under section 20 clause 2. I am reading section 20 clause 2. Correct? This is where, where the rules come in. So the format has been given. What will you go? You will go forward, of course, to the authority appointed. It could be a civil judge. It could be labor commissioner, regional labor commissioner. You will have to check for your area. Okay. Applicant name versus opponents कौन है, right? The applicant has been employed in so and so category, in so and so establishment, in so and so nature of work. It is a scheduled employment within the meaning of 2E of Minimum Wages Act. Okay. Opponent is the employer. Employer कौन है? आपका manager, supervision and control, head of department, CEO, या person who has supervision and control. Correct? These are your employers. Applicant has been paid wages less than minimum rate of wages. How do you identify what are the minimum rates of wages? You go to the department's website, you pick out the latest notification and you see what is your entitlement. Okay? आपका कितना wages pay होना चाहिए था, और applicant को of course कब से कब तक पैसे नहीं मिले हैं, you need to show it to the court, and relief का value क्या है, and you issue a direction. सबसे पहले तो payment of remuneration for days of rest, payment of wages for overtime नहीं दिया है. Compensation भी मिल सकता है employee को if the employer is not paying, and the compensation can go up to 10x of what is not paid. Okay, that is given under the act. The act says, ठीक है, has everyone followed, कि अगर आपको कम पैसे मिल रहे हैं या आपको ओवरटाइम नहीं मिल रहा है तो आप क्लेम कर सकते हो सेक्शन 20 में. दिस क्लेम विल गो बिफोर द कमिश्नर, लेबर कमिश्नर और एनी अदर अथॉरिटी व्हिच इज जज ऑफ सिविल कोर्ट. ओके, देन it could be done by yourself, by a legal practitioner, or by the inspector themselves. Okay, you have to do this within a period of 6 months. Okay, now if the application is entertained, okay, the authority is entertaining your application, what will the authority do? They will hear the applicant, they will hear the employer, correct? Both parties will have a hearing. Of course, opportunity of being heard will be given, and without prejudice to the other penalties to which the employer may be liable. Other penalties are there under the act. Without prejudice to all of them, what can the authority direct? Number 1, in case of claim arising out of payment of less than minimum rates of wages, the payment of employee of amount which minimum wages payable to him exceed the amount actually paid, together with payment of such compensation as the authority may think fit, not exceeding 10 times of amount of such excess. तो जितना पैसा मुझे मिलना चाहिए था वो अमाउंट से 10 टाइम्स तक मुझे कॉम्पेंसेशन भी मिल सकता है. तो ऑफ कोर्स आई विल गेट द अरियर ऑफ नॉन पेमेंट and I can get a compensation of 10 times of the amount if the authority feels that okay, this act done by the employer was wrongful, close to irrelevant. 10 rupees is not relevant here. Okay, if the authority on hearing the application under this section is satisfied that either it was malicious, okay, probably the employee is filing an malicious or vexatious application, then there can be a penalty on the employee which is 50 rupees, but check for your state notification. There could be modified penalty amounts for this section. Okay, how do you have to do it? Any amount directed to be paid under this section, the authority, if it were a fine imposed, okay, you have to recover it in that manner. Of course, decisions would be final here, and authority has powers of civil court. Basically, the civil court can take evidence, they can ask for production of documents. So all of those powers of civil court are given to the authority. Okay. Last is, what if